All right, everybody. Thank you for joining us for Edwards versus Aguillard, U.S. Supreme Court, 1987. This is case citation 482 of United States 578 in 1987. So this case was argued in front of the Supreme Court on December 10th, 1986, and then affirmed in 1987. All right, so hey. Pay attention. All right, a little bit of background on this. So in the 1920s, the fundamentalist Christian movement began promoting state laws that prohibited the teaching of evolution in public classrooms. And then in 1981, Louisiana passed the Balanced Treatment of Creation Science and Evolution in Public School Instruction Act, aka the Creationism Act. So what does that mean? That meant that basically, if they were going to teach anything to do with evolution, they were going to have to teach creationism science. But at the same time, if they didn't teach either one, they didn't have to really worry about being equal with it. So one of the best things they could have done was just stay away from the teaching of evolution. However, you're talking about Louisiana and down in the South, which that math just don't work, because talking about being in the Bible Belt, obviously no judgment passed on that, but they're more concerned about making sure that creation science is taught as well, but are not equally wanting to share their the rights of people who believe in evolution. So, in 1981, the Balanced Treatment for Creation Science and Evolution Science in Public School Instruction Act was passed in Louisiana, and then that also became known as the Creationism Act. So basically, evolution, so this is Charles Darwin right here, and the idea of Adam and Eve in the Garden of Eden had to be equal within the classroom. Alright, so what happens now? Alright, so that meant that Governor John Bel Edwards in the state of Louisiana went up against Donna Aguillard, parents, religious officials, and community members to officially say, hey, look, this is not really about making sure that we're not teaching creation science and that we're not doing that we're not being equal to evolutionary sciences as well within the classroom, but more about the protecting of academic freedom. If the teacher wants to teach about one thing, they don't have to pick between the other. However, the Creationism Act specifically said one or the other, or said one and the other, not either or. Okay, so that's whenever Donna Aguillard and the parents and religious officials and all of them, they all went up and then the court said, yeah, that's definitely right. So they confirmed with Donna Aguillard, and then that's whenever Edwards and the state officials who were responsible for enforcing this law, the Creationism Act, went ahead and appealed it to the district court, where the district court ended up coming into action, and they basically said, we see, so they came down to the idea that the argument was kind of split. But then Aguillard and her team were like, we seek an injunction and declaratory relief. But then Edwards came through and was like, well, and so with his bad attitude, he essentially was just saying, hey, like, he thought he was going to get his way. He was very liked politically, but that's whenever the court ended up saying summary judgment was granted, and that they agreed with Aguillard and said the act violates the Establishment Clause of the First Amendment, and that it did not have anything to do with protecting academic freedom, but more about stating secular purposes within that freedom. Okay, so what's going on now? So essentially, Edwards is like, hey, look, we lost here, but we still want to affirm that we believe that the Creationism Act serves the best purpose of the students of the state of Louisiana, so they're going to take it to the Supreme Court of the United States. Okay? And eventually, it came down to the decision. That's that December 10th decision. Okay? So, whenever it got to the decision, It was a 7-2 decision. The only two people who did not agree with the Creationism Act ended up being Justice Rehnquist and Justice Scalia, which is not really surprising because they were both very conservative, and although the idea of being on the Supreme Court would indicate that you are a non-partisan, that opinions do not matter, but it's all about constitutional ruling. But on a 7-2 decision, it was declared, the decision served that it was unconstitutional for the state to mandate that you only teach one secular belief or science over the other. Okay, so what else does that mean? So looking forward at that, the Louisiana law was unconstitutional teaching of creation in public schools, and it had no secular purpose and in no violation of the Constitution. But the opinion of Donna Aguillard is that it violated their Establishment Clause. One of the main dissenting opinions was that the Louisiana officials, including Governor Edwards, argued that it was constitutional that protected a legitimate secular interest, mainly academic freedom. And as it went through the appeals court, the Supreme Court went ahead and confirmed, and then it went down back through the justice system. So ultimately, what's this mean? You cannot have your cake and eat it too. Protection of specific secular beliefs on grounds of academic freedom is a tough battle to fight. Ultimately, you got to consider it's kind of like the see you at the pole events and fellowship Christian athletes. Okay, if schools allow one secular belief to openly practice within schools, then all should be allowed. Okay, just think how many Muslim students are allowed prayer times throughout their instructional day. Okay, so this is going to lead us later on into the semester where consider the more recent decision with Kennedy versus Bremerton, where a football coach led a prayer on the field, ended up losing his job, and ended up going up to the Supreme Court. All right, so the issue was that prayer prior to games is typically said by students. However, the student ended up being led by the coach, and so that almost meant that the students had to take on that coach's beliefs. So the implications of Edwards versus Aguillard is that if you are teaching one secular belief over the other, then the impressionable actions of the teacher could potentially be pushing one student or multiple students into one direction or the other that do not coincide with family beliefs, and can potentially be considered educational manipulation. All right. Thank y'all for your time, and that was Edwards versus Aguillard. Okay.